Hey everyone, Harry here to talk about the all-day hearing currently ongoing in Judge Cannon's courtroom in Mar-a-Lago to consider two motions to dismiss that Trump has filed. Now, first point to note, this is her doing. He's got seven motions to dismiss, I believe. She chose two of them and just announced we're going to have a hearing about those, and it could go all day. The two motions are like stunningly without merit. Now, that doesn't distinguish them from among the pack of seven, but that a judge would single out these two and say, let's talk about them all day is, complete departure from how things would happen in most courts. Even complicated motions might take an hour or two, and these are really uncomplicated motions. So we've got a real Alice in Wonderland quality to this hearing, because you could I will impose best I can or articulate the normal legal analysis. But then you have to overlay on there the filter or software for Judge Cannon, who has rarely, if ever, met a Trump claim, however meritless, that she doesn't like and at least will toy with. And so you have to guess where her interests may be. Oh, but that's very hard too, because either her style, perhaps informed by the combination of her pretty scanty experience and the tremendous scrutiny she knows she's under, is to be kind of Delphic on the bench and just have the parties go on. And so you'll have Trump, and she's declared, by the way, in this hearing, first she's going to hear from Trump for both motions. Again, unusual. You would normally zero in on one, have the parties argue that. But there's all kinds of procedural ways in which she seems often to give little advantages to Trump's side. And by the way, Trump's side here includes today Donald Trump, who is more than the putative. I think he's now, you'd have to say, the official nominee of the Republican Party. He's secured more than enough delegates. He's spending the entire day in a courtroom in Mar-a-Lago. Normally, a defendant or a party wouldn't be there at all. A motion to dismiss is just a legal argument. It's on the papers. You don't need that person, and they wouldn't understand it anyway, especially a busy, magnificent brand owner. So what's going on here? Some combination of being able to play this to his political faithful, but I think more, it feels like a crass and unsubtle way of being in front of the judge and reminding her how she got there and what could happen if he's reelected and the like. So that sort of sets the scene. We're ongoing. Trump is there. Nauta is there. Two lawyers for Oliveira, but not Oliveira himself, but a bunch of lawyers, and then three prosecutors, including Jack Smith. Okay, and we're arguing two motions. And again, there's the merits of them, and then what possibly could Cannon seize on, and even seize on after the hearing, because there's a real sort of unfairness to the way she operates. She just sits there, hears things, and then can come out with total whack job of opinions, whereas a judge worth her salt would at least confront the parties with them, work through her suppositions, and see whether they hold water. That's really, that kind of interaction is the hallmark of a good judge in a hearing such as this one. But I don't think we're talking about a good judge in a hearing such as this one. All right, two motions, and she's first doing the motion that Trump says that his indictment under 32 counts, but especially the main idea of 793E, the unauthorized possession of national defense information, is unconstitutionally vague. So just to understand what that means, the due process clause, we're talking about the bare basics of fairness, just says that you need to know what they're charging you with. Seems obvious and fair enough. So if the government issued an indictment against you saying, you broke the law last March, that would be void for vagueness because you don't know how to defend yourself. The sort of feature of both these motions and that Trump is bringing are really, he's making factual assertions that, if true, and they're not, might provide defenses. But even if true, don't make the charges, in this case, void for vagueness, nor do they make them a problem under the other motion, which I will get to in a moment. So that's void for vagueness. And so now go to the actual act that he is charged with violating. And his argument is Section 793, which is based on the original Espionage Act, and says you can't have unauthorized possession of national defense information, is somehow unconstitutionally vague. First inconvenient point for him: every court that's considered this argument, and it goes back over 100 years, does the statute, has rejected it. I shouldn't chortle. I take that back. I mean, it's really just, it's just so straightforward, such a lousy argument. And again, you wouldn't give it a second's thought, except now we are in the Alice in Wonderland courtroom. Basically, there are phrases there that he's saying are unconstitutionally vague. Unauthorized possession of a document. That seems very clear what it means. You have it and you aren't supposed to. He is trying to say, because of his presidential authority and his crazy ass Presidential Records Act defense, that it's authorized. Well and good. Well, not well and good. It's a lousy argument that doesn't hold water, but it doesn't make the notion of unauthorized possession void for vagueness. It's perfectly clear what that means. Same thing related to the national defense. That's actually a little bit more, open-ended, but again, you understand what you need to know to prepare for it. You could imagine documents at the margins where you can make factual arguments. I don't think these were related to the national defense. The, memos about what Putin likes to eat for dinner. All right, I'm trying to think of something that you could argue either way. But the ability to argue it either way is not the same as saying that the basic charge just can't be understood or reckoned with, and it's a due process violation. And finally, willfully retain and fail to deliver. Very, straightforward what that is. So on his side, Trump's side, are just these exotic arguments having to do with either the ability of a president to declassify or basically to be above the law. They're offensive arguments to the Constitution, but they're irrelevant arguments to the motion to dismiss here, because the motion to dismiss is precisely, I can't possibly figure out what the government is charging me with, and therefore I can't make my defense. And that's really a garbage argument. And we wouldn't be spending, I wouldn't be spending this much time on it, except, now try to figure out how Cannon could entertain it, flirt with it, go down the line with it. Would she try to say, well, what does it mean related to national defense? Or she's also, of all the judges involved in Trumpland, the one who's been most open to the notion that things are different for the president. So, will she try to say, in his case, how can we be sure, truly irrelevant kind of discussion, again, because at most it would be a factual defense he could try to make at trial. but not something that should in any way deter things here. Okay. The other one, which is going to be argued second, is his hobby horse that he goes on and on and on with, that the motion should be dismissed because the records he possessed were, quote, personal under the Presidential Records Act. The Presidential Records Act does give some ability for a president to designate certain things as personal. Like diaries have been a sort of interesting close call. This actually came up with Biden, came up with Reagan. But the newspapers that were strewn in some of the boxes, etc. But not, not the notion that he, even, again, this is an even if kind of argument. So on the facts, so it's a lousy argument on the law, but even worse on the facts, because even if the facts were true, they would be irrelevant. So let's say he somehow, in some this is his argument, is that just because he put them in a box and stole them, essentially, they became magically declassified and became personal records, therefore not subject to the indictment for unauthorized possession of records related to the national defense. But it's such a patently transparent, poor argument. So first, it's bullshit to say that he had done this hocus pocus thing, because that's not how it works to declassify. That's for starters. But fine, let him try to argue it. Again, that is a factual claim to try to make at trial. If a jury then accepted it, we could think about it. But it's not a motion to dismiss, because you and a motion to dismiss, you assume that all the allegations are accurate. The ability to possess classified information is part of a whole classified scheme and not the Presidential Records Act. So even if it were true that you categorize them, and I say, oh, see all these records about our nuclear secrets and how we're going to go to war in Iran, I've just made them personal. Isn't that neat? Doesn't matter, wouldn't override the scheme of whether you're allowed to possess the information under the applicable executive order and not the PRA. So it doesn't get him anywhere, and it's a factual argument. Second, they are not personal, they are presidential. There's no legal basis for his magic parthenogenesis of just, transmuting hocus pocus into personal records. We know what they are. There may be borderline calls, but they're not, what we're going to do to go to war with Iran and the like. These are presidential records, and he's given no, possible argument. Oh, and he's also saying, by the way, in his total corruption of Marbury versus Madison, that a court can't even review. That strikes me, now that I say it out loud, as the kind of total whack job supposition that maybe does attract some canon to, at least for a bit. And then finally, even if it were right, that, it's got nothing to do with the criminal law. It doesn't mean that the Justice Department can't, investigate and enforce violations of 7-9. I chortled again. I'm sorry. It doesn't mean that the Justice Department can't investigate criminal violations. There are things you can do under the Presidential Records Act in a civil action if you think this is yours or not, but nothing about it displaces criminal law. So it again is wrong 6 ways from Sunday. And the very, very best you could say for it is, if his factual assertions were accurate, even then, it probably wouldn't fly, but at a minimum, it's based on factual assertions that would have to be proven at trial. So all of this is just way upriver, wouldn't deter 99% of judges for more than a few moments. But now, again, we have the good judge canon thinking things through, and working them over to death. There's a motion for reconsideration, you may remember, that's been pending for weeks, where she's really dead wrong, but she hasn't ruled yet. And now, likewise, there's going to be a day of stuff for her to chew on, and you don't even know what what could attract her or not. I think either of these would be easy fodder to bring up to the 11th Circuit and reverse, were she to allow them, and couple it with a motion to recuse her. So, that's really the thing that is over her head now. But that's true of these other motions out there too. It hasn't prevented her from kind of going wacky off the sort of normal path before. So there's just an unpredictable Alice in Wonderland element to all of this that, you can just try to speculate on. I think the most likely outcome is she keeps this a long time, more delay, and then denies it, though maybe with some partial statements that help, that prejudice the DOJ at trial or whatever, but not that she actually pulls the trigger on granting either of the motions. But this is Judge Cannon. So, it's anybody's guess, because it's cryptic what motivates her, but we certainly know that again and again she has inclined, at least both in entertaining and sometimes in ruling, for claims of Trump that would never stand up in other courts. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.